Here's the latest and most recent update with regard to Alec Murdaugh's quest for a new trial. The first being that the Chief Justice of the South Carolina Supreme Court filed an order about an hour and a half ago, indicating that all future filings related to Alec Murdaugh's quest for a new trial shall be filed with the South Carolina Supreme Court, not the Clerk of Court for Colleton County, Becky Hill, because Becky Hill's interference with the jury is the subject of the request for a new trial. Now, that's something I've never seen before, the South Carolina Supreme Court accepting state court pleadings, but there's a lot in this case that I've never seen before, so just add it to the list. There's also been a pretrial conference scheduled for January the 16th between the state, the defense, and Justice Toll, and because Justice Toll is transparent, that hearing will be televised January 16th. Now, at that hearing, Justice Toll will likely be deciding what the standard of proof is that must happen at the evidentiary hearing that is scheduled for January the 29th. The state is arguing that Alec Murdaugh must show that a juror, at least one, was actually biased because of Becky Hill's interference. In other words, that Becky Hill's interference changed their position, made them change their vote. Shockingly, the defense has a different point of view, arguing that you do not have to show actual bias on the part of the jury members. In their pretrial brief that was filed today, the defense cites case law that says where there was a private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. In other words, they're arguing that harmless is the standard. If her context of the comments that she made was harmless, in other words, hope you have a great day, then no new trial. But if it was about the trial itself, then that's not harmless. In that brief, the defense actually states, asking the jury what they want for lunch, harmless. Telling them not to believe the defendant's testimony, not harmless. Other interesting things that came out of this pretrial brief, I think the defense and the state have agreed to allow Justice Toll to question the jurors, to maintain their privacy and the sanctity of the jury system. She will be conducting in-camera, meaning back in chambers, hearings, questions with each juror. That will not be publicized. What will be publicized and aired on TV, if anything, will be Becky Hill's testimony. The funniest part of this brief is when the defense states that the state said Becky Hill was above reproach, and then they said that didn't hold up so well now, did it? No, it didn't. They are also arguing that Becky Hill should not be allowed to plead the Fifth Amendment because she gave an affidavit in this case denying every single allegation, and therefore she should not be allowed to plead the Fifth. This is going to be one interesting pretrial conference.